Hi there, and thank you for coming to my YouTube channel today. I'm here joined by my buddy, Murphy's Law. What could go wrong will, right? We've all been there. If you live long enough, a couple of things have gone wrong, but that's what I'm here for, right? Help you out through these difficult times. I know bankruptcy is a subject nobody wants to talk about, but at the end of the day, it's all about taking down, walking down that path of financial freedom, and that's what I'm here for, right? I'm your personal professor here, Alex Hernandez. So today I'm going to talk about the issue of divorce. Now, divorce and bankruptcy go hand in hand. Most people don't realize that, but the reality is the top three reasons people file for bankruptcy are medical bills, health related issues, and divorce. Sure, are people out there spending tons of money on stuff they're not supposed to, and living above their means? Of course, but that's not the top three reasons. Divorce is in part of that top three reasons. So when it comes to divorce and bankruptcy, it gets complicated real fast. There's a lot of issues at play, and especially if we're dealing with the issues of a house. When we're dealing with a divorce and there's marital property involved, of course, the question is always, are you going to sell it? Sometimes the parents agree to wait till the child turns 18 and then sell it at that point, or is there going to be a refinance? Of course, you can give the property to the other spouse. If there's a refinance, that is the only way to protect yourself. That is an issue that most clients miss out on. And the reason is they do simply, as you see here, the quick claim deed. Now, let's go over what a quick claim deed is. A quick claim deed is simple enough. It is nothing more than a transfer of property. It's a one-page form. Everybody puts $10 for an interest of $10. They transfer the property to you. Is that enough to avoid liability? If you're not on the mortgage, sure. But if you are in the mortgage, we have other issues. And the issues with a lot of times people don't realize this, even just my students, is we're talking about contract law here. You signed a contract with the bank. We are both responsible for that mortgage. Just because one of you or both of you decide to, get off the property, that doesn't eliminate the original mortgage. What happens in family court has nothing to do with what happens regarding that mortgage. So if you stay on a mortgage, understand there are possible consequences to that. For one, your debt level is going to remain the same until that mortgage gets paid down little by little. What does that mean? It means if you go and apply for credit, whether to buy a new car, home, or even a credit card, you could be denied that because the bank is already seeing you have a mortgage, you have rent, and this mortgage is $200,000, $300,000, whatever it might be. You might get denied. The bank, sure, do they understand that there was a divorce and that you signed a piece of paper, the marital settlement agreement, saying you're not responsible? Yes, that's very important. But you're still responsible to the bank. You're not going to eliminate, this original contract that you had with the lender. So the problem is that, of course, will take a toll on your credit score. And to make it even more of an exaggerated scenario, if your spouse is making late payments, it's going to affect your credit score. Could you dispute that in your credit report and say, well, here's the divorce paperwork? Yeah. Is it going to do much? Probably not, because at the end of the day, it's all about numbers. And if a new creditor comes in and sees that you owe this on this mortgage, even if it's getting paid timely, unless you have, the amount for a substantial deposit and sufficient income, they're going to reject that loan. Now, part of the issue with that is your credit score. Your credit utilization ratio, this works on a magical number that we call the 30% rule. So to build up your credit, whatever debt you have, the bigger the gap between how much you owe and what the line of credit is, the better your score. And the idea is to get it to this magical number, 30% or below. So for example, if you have one credit card and the total available credit is $10,000 and you owe 7,000 on that, 70% of your credit has been used. Do you pay timely, every single month for years? Sure, but it's still 70%. According to creditors, this could be an issue. So they look at 30%. So if you owe 3,000, 2,500, etc., that is going to improve your credit score. My credit score just went up recently, took a big boost. One of my credit card companies gave me about a $5,000 or $6,000 increase in my line of credit. That increased the gap now that I had before. So imagine if I owed $5,000, right? And I had a $10,000 line of credit, I owe 50% still, no matter how many times I've been making timely payments. But now you add 5,000 to that, and my percentage goes down dramatically, and that will improve my credit. And guess what? It did improve my credit drastically. Literally, I've gone up about 20 something, 20, 30 something points. So let's go back to this issue of the quit claim deed. Assuming everything falls in order, there's a couple things that I've seen mistakes, whether it's the judge on a court order, they have a trial, they don't put this down. They'll say party's going to refinance or sell. By when? We need to have a date specific. So a lot of times you say, well, the person is paying late. This is affecting my credit. Well, okay, no problem. When did they have to refinance or sell the home? There's no date on it. Okay, well, infinity means infinity. So unless it said 6 months, lawyers typically put 90 to 100 days to refinance. And if it can't be done during that time, then the property has to be sold. So make it date specific to protect you. You don't want this debt hanging around forever. Maybe things even go bad in those 2 or 3 months. You can make those mortgage payments to protect your credit, and you can pursue credits later. But imagine if it's been 5 years. What if you have your ex-spouse lost their job? They're not even doing this on purpose. It's still going to affect your credit. Creditors don't care about the reason why, they just know the why part. So you got to be careful with that. The other issue I see is a lot of times there's concern about, well, I do the quick claim deed, and what guarantees do I have that they're actually going to go forward with the refinance? I get it, right? It's your ex-spouse. Maybe there's some trust issues there. Well, simple enough. Sign the quick claim deed and hold it, or the day of the closing, depending on the state you are. Some states like Florida use a title company. Other states just use a lawyer. Even in Florida, title companies typically there's a lawyer involved anyway. But if you're, whatever it is, if it's the bank or just a separate law firm or title company, tell them prepare. When's the closing? Tomorrow at 10 o'clock. I will be there tomorrow at 10 o'clock. Make sure you have the quick claim deed ready, and I will sign it right then and there. That's good enough. The quick claim deed doesn't have to be signed a month or 3 months in advance. It could be signed the same day. So that will protect you if you're concerned of signing the quick claim deed and all of a sudden your spouse can't get approved. Now you're running back to court to resolve this issue. But that's what I want you to learn from today's video. Understand that the quitclaim deed is not going to protect you 100%. If you're still on the mortgage, that is a contract with that lender. And unless there's a refinance, you continue to be responsible. So you ask any divorce lawyer, many times they've had that conversation where he says, I know the divorce agreement says that you have no responsibility with the loan. To a certain extent, that's true, but that doesn't apply to the lender. So when they foreclose, they're foreclosing on both of you. And sometimes you see people having to file bankruptcy 10 years after they got divorced because there was no specifics as to the refinance or the sale of the property. Okay. Now, as always, I always close out my videos with the same. If you paralegal students that are using my textbook in your courses, you have any questions on the video today, feel free to post them in the comment section below and I'll reply. And all of these that are not paralegals, feel free to post any comments that you have, like, subscribe, all that stuff that I always forget to say, but you always see a little sticker jumping up there. But always feel free to reach out to me if something wasn't clear in the video. All right. So take care of yourselves. You know what to do now when it comes to divorce and issues of bankruptcy down the line. Make sure that there's a date certain on that refinance or a sale date to protect your credit. Take care, everyone, and I will see you at the next video. My buddy Murphy's Law is going to join me too.